Mr. McKnight, you may proceed.
May it please the court. My name is Daniel McKnight. I represent the appellant, Kathy Jennings. I'd like to reserve 5 minutes for rebuttal. The JCC erred as a matter of law by denying costs on the basis of the 30-day attorney's fee provision. Costs are not a type of attorney's fee. They represent different interests, serve different purposes, and are treated differently by the statute. Under the statute...
All right, so your position is that that was the wrong basis on which to deny costs, but maybe they should be denied on some other basis.
No, costs should have been awarded as a matter of law because the claimant prevailed. When a claimant prevails or when any party prevails, costs must be awarded.
Well, didn't you take a dismissal?
I'm not sure what you're asking.
On what basis do you say you prevailed?
Kathy Jennings prevailed because she received the benefit that she pled in her petition for benefits. That when a benefit is requested and thereafter provided, entitlement to that benefit is established.
Do we know the sequence? Or was it appointment set before the petition was filed?
It doesn't necessarily matter when the appointment was set. It's when the benefit is furnished, and in order to be furnished, it must be set. And the claimant,
right? Isn't setting the appointment furnishing the medical benefit?
No, the claimant must be informed of the appointment, and the judge found that occurred on the 12th, the day after Habana Health received the petition and forwarded it to Gallagher Bassett.
All right, so even if all that was in process, before you filed, you get costs. In other words, let's say the appointment was already set and it was somebody calendared to call the claimant, and then the petition is filed, you still get costs.
There's no evidence to indicate that was the case, and the judge didn't find that it was in progress. I would also argue that even if it were in progress, the employer carrier had options when they received a petition, and where it's demonstrated that where a claimant becomes entitled to the benefit, she's prevailed.
Where I'm going is, do we have to send this back to find out if it was in progress?
No. Causation, I don't believe, is a requirement, and she didn't.
All right, so we've got the findings. She had not been informed when the petition was filed. Only thereafter was she informed.
Yes.
And that's what counts as furnishing the benefit. And you get costs.
Yes, Your Honor. That in Mitchell v. Sunshine Companies, this court held where the benefit was provided after a mediation, but that didn't address causation.
I'm sorry, I didn't understand that argument. What happened in that case?
In that case, addresses whether providing the benefits establishes entitlement, and I believe that case isn't relevant to your question here.
So basically, your argument is that she didn't get anything until after she filed the petition for benefits, and that triggered the right to costs. Is that in a nutshell
Yes.
what your argument is?
She fractured her acromion on the 1st. The petition wasn't filed until the 9th. It was 2 days until Habana Healthcare received the petition and they forwarded it. And the benefit wasn't furnished until the 12th, so 2 working weeks until she was informed of her opportunity to go to the
Now, there was, it seems to me like when she first had the injury and went to the clinic or whatever, you know, the urgent care clinic or whatever she went to, there was something in the doctor's note saying she needs to go immediately and get this, you know, orthopedic emergency, but that was not communicated to the employer carrier. Is that right?
The JCC found that there's no evidence whether the MedExpress provided that report to anyone. But it was attached to the petition, and the petition was served on Habana Healthcare and forwarded to WorkComp Strategic Solutions and again to Gallagher Bassett.
Okay, so from her perspective, she goes to the doctor says you need to go to get this orthopedic treatment, and then crickets, you know, nothing happens until she files her petition for benefits, correct?
Yes, Your Honor.
Okay, so then she says it was the petition that made her prevail in getting the benefits, and as the prevailing party, she should get her costs. Is essentially what, okay.
Providing a 30-day grace period in effect would defeat the mutuality purpose of the statute, of the cost statute. Either party is permitted to receive costs if they prevail, and a one-way grace period would defeat that purpose. Also, when a petition is served, the recipient has options. They can accept entitlement, pay the benefit, and pay the costs. They could also deny the benefit, and they could prevail. And in that way, they would avoid paying costs. They may have also been able to elect to pay and investigate. And after an investigation, determine that maybe the individual wasn't entitled. But where there's no question that she was entitled to go to the orthopedist, I believe she prevails. If there are no further questions, I'd like to reserve 5 minutes for rebuttal.
May it please the court, I am James Hess and I represent the appellees. Simple, am I supposed to hit anything?
No, you're good.
Okay. Simply stated, in this case, the claimant did not prevail. If you go by the timeline, what actually occurred, and it's in the record, September the 10th, the employer notifies the carrier of the accident and the injury. That's when they received the notice of injury. They opened a file. They had the report from Dr. Kidd, which was issued, I think.
Is it in the record when they received the notice of injury?
Yeah, testimony of Jackie Weimer, the adjuster, said it was received on September 10th. That's when they opened.
What about the visit to the urgent care place?
Okay, well, what typically happens, and this is not in the record, but from experience, I can tell you that the employer, if somebody gets hurt on the job, the employer sends them to a place like urgent care or something like that. And I'm sure that's what happened in this case, that Mrs. Jennings was referred to urgent, or I think it was MedExpress actually, by the employer. And I believe that the doctor.
So written notice on the 10th, but the day of the accident, there was.
No, I don't know why the employer didn't send a notice of injury into the carrier till September 10th. But that's what the record states, that the carrier received notice of the injury on September the 10th.
Well, when was the petition for benefits actually filed? That was the 9th, right?
Well, they served it on the 9th, and the employer sent it to the carrier on September the 11th. On September the 10th, when the carrier received the notice of injury, they had not yet received the petition for benefits. They opened the claim on September the 10th. On September the 11th, they scheduled an appointment for the claimant to see Dr. Green, an orthopedic surgeon, on September the 15th, just 5 days later, or 4 days later. In fact, it's in the record, at 2:01 on September the 11th, they received the PFB from the employer. That's when they first became aware that Mrs. Jennings was represented by an attorney. There was no evidence that they received the PFB before they set the appointment with Dr. Green.
Right, but he's right, they have to communicate it to the doctor and to the claimant, right?
Well, Your Honor, again, I don't believe you have to. You set the appointment on September 11th. They notified the claimant attorney on September the 12th because they didn't know on September the 11th when they set the appointment that she was represented. I don't believe you have to notify the claimant the very time you're setting the appointment, as long as you do it within a reasonable time. And I think one day later is certainly very reasonable. There's no evidence, and this is important.
The cases don't tell us when the benefit is furnished.
The benefit is furnished well, I agree. There's case law dealing with the 5-day rule and the 3-day rule that is furnished when the claimant is notified. But that's not the issue here today. The issue here today is, was a benefit timely provided? And there's no evidence that the benefit was provided because the PFB was filed. I submit that she would have seen Dr. Green on the 15th, regardless of whether she got an attorney and whether a PFB was ever filed. The claimant attorney filed a PFB on September the 9th.
Well, certainly the JCC did not find that, right?
Right, that's correct. The JCC did not file.
So should we send it back for the JCC to?
Because it's in the record. And I don't think it should be sent back because there is no evidence in the record. The testimony of the adjuster was, I don't know whether or not I had the PFB when I set the appointment with Dr. Green. That's already, so what are you gonna send it back for? Have the adjuster say again, I don't know whether I had the PFB when I set the appointment with Dr. Green. And the judge found there was no evidence that the PFB prompted the scheduling of the appointment with Dr. Green. So I don't see any point in sending it back to the judge of compensation claims because the evidence is there and there simply was no evidence.
Okay, so your theory is there has to be a causal connection, and you say it's clear on the record already that that cannot be proven.
No, it can't be proven, that's correct. I'm gonna get to the.
He says the mere chronology, the filing coming before the notification makes him entitled to costs.
I don't believe so. I think you have to prevail. And nothing was being denied. There was never anything denied in this case. Now, the judge also in her order refers to Florida statute 440.192 subsection 8, which states that a carrier upon receipt.
How long do you have to answer the petition?
Well, that's the statute I was just going to tell you about. The statute states that a carrier has 14 days from receipt of the petition for benefits to either provide the benefit or file a response to the benefit. I'm sorry, to the petition, excuse me. And in this particular case, everything was done clearly within 14 days. The response to the petition for benefits was filed on September the 18th, within 14 days of the petition being filed. The benefit was provided, and I still submit it was provided on September the 11th. But if you want to use the other day, provided on September the 12th, we're still well within the 14 days. The statute would have no purpose or function unless it gave time to the carrier to investigate, to make a determination as whether they should provide the benefit. And they shouldn't be held responsible for costs where there was no intent to deny the case, where they are investigating and they provide the benefit within the statutory 14-day time period. Now, if they'd gone beyond 14.
None of this was the JCC remotely focused on. She conflated costs and fees.
She used, I think, fees as sort of a guidepost, but I don't think she was relying on. She does cite Florida Statute 44.192, subsection 8 in her order, and only to state that this was slightly modified in the attorney fee context, in that another statute gives 30 days to the carrier to provide the benefit to avoid attorney's fees. That's the sole purpose of the attorney's fees act, the modification by 440.34. But 44192, excuse me, states clearly that the carrier has 14 days in which to either provide the benefit or to provide a response to the petition for benefits. Now, they could deny it in the response, and if they later rescind it, obviously they owe costs. If they fail to respond timely, I think they would owe cost. But in this particular case, the carrier did everything on a timely basis, and the claimant did not prevail, and therefore is not entitled to their cost.
So you're saying if you furnish benefits within 14 days, you never get hit with costs?
I believe that's the purpose of the statute. Well, why not? Why have the statute? This, the purpose of the statute is to give a reasonable time for a carrier to investigate, to make a determination as to whether they need to provide the benefit or not provide the benefit. And there's all kinds of examples of that throughout the workers' compensation statutes. They have 5 days to provide a one-time change of doctors, 3 days to make a medical referral to a specialist, 7 days to pay, or else they pay penalties and interest. There are time periods built all throughout Chapter 440 that gives the carrier an opportunity to investigate. And these are reasonable time periods too. They're like for payment of benefits, 7 days, for authorization of a specialist, 3 days, for one-time change of doctors, 5 days. In this case, for providing a benefit that's being requested in a PFB, 14 days to either provide it or file a response to the PFB. And I believe if they do what they're supposed to do within the 14 days, they don't owe costs because the claimant did not prevail.
Don't you have to furnish medical benefits within a reasonable time? I know you have the special time periods for like specialists and so forth. But.
Well, I don't know of any specific statute that says you have to a reasonable time, but I think reasonableness is built in to the entire workers' compensation law. I think you're supposed to do everything on a reasonable basis, and you should provide medical benefits and medical treatment on a reasonable basis, but I don't know of any specific statute. But again, we have all of these time limits that are built into the law that gives the carrier an opportunity to investigate and determine whether or not they have to provide the benefit or not provide the benefit. In this particular case.
What costs and in approximately what amount would typically be incurred by a claimant within the first 10 or
I would argue that
14
only
days?
taxable costs under the Uniform Guidelines for Taxation of Costs would be available. In this particular case, it would have been the 2 certified mail receipts that were sent. Mr. McKnight used certified mail as opposed to e-filing. I don't know why, but anyway. The other costs he was alleging were for photocopies, and I'm not sure if those are properly taxable under the Uniform Guidelines for Taxation of Costs. So I think they were alleging $33 or $44 in costs, of which I think about 13 was for certified mailing receipts, and the rest were for photocopies.
I mean, is it conceivable that there would be huge costs incurred during this period?
Actually, I agree. I don't think it would. Most of the time, we're going to be dealing with very minimal costs. And in most instances, you shouldn't have any cost at all, because if you e-file your PFB, that doesn't cost you anything. And the statute allows either certified mail or allows e-filing. They elect to do certified mail, that's fine. But arguably, you could avoid costs altogether in filing your petition for benefits. And if there are any costs, they're going to be extremely minimal. And if, for instance, in this case, I would be arguing that he's not entitled to reimbursement for photocopies because the Uniform Guidelines of Taxation of Costs don't permit that. So I wouldn't argue he wouldn't be entitled to the certified mail, whatever that came to. I think it was $13 or $14. But again, the cost probably in every instance would probably be extremely minimal because there's no time to set depositions and send out subpoenas and do that sort of thing, because these time frames that we're talking about are fairly short.
Yeah, so you're switching ground on us. You're saying you're putting the causal thing to one side, and you're saying that you have an absolute window of 14 days.
Well, actually,
they
making
can't prevail until issue is joined.
I'm making both arguments. I think that there was no causal connection in this case between the filing of the PFB and the provision of Dr. Green as the orthopedic surgeon. I believe that was done independent of the PFB. But even so, even if it did prompt it, then I believe they had 14 days from the date the PFB was filed in which to provide the benefit. And they did provide the benefit within 14 days clearly. I mean, well within the 14 days. And they filed their response to the PFB on September the 18th, and so they're clearly within the 14-day window there. So they complied with the statute. I am contending, however, that it's probably not even necessary to go to the statute, because I don't believe there's evidence that the PFB prompted the provision of medical treatment in this case, the authorization of Dr. Green, the orthopedic surgeon, and therefore the claimant did not prevail.
How would you prove causation? How would you prove that it prompted it?
Well, the adjuster testified, was asked, did you have the PFB when the appointment was set? She didn't know. You take the adjuster's deposition. In this particular case, there was no discovery.
We know the employer had it.
The employer is the one that sent the PFB to, the employer on September the 11th sent the PFB to the carrier.
And got it on the 9th.
I don't know when I don't think there was any evidence of when the it was mailed on the 9th. I don't know when the employer received it. It was mailed on the 9th, again by certified mail. So I don't think the employer would have received it on the 9th. Our post office does a great job, but not quite that good. So I think most likely they received it on the 11th is what I would guess. And upon receipt of it, they said, oh, we better get this to our carrier. There's a lawyer involved, and they emailed it or faxed it over to the adjuster. And it's very specific in the record that
They probably got it on the 10th. That's when they did the notice of injury.
the notice of injury was the 10th. That's a different animal. I was talking about the PFB.
I know, but that's probably what inspired the notice of injury.
Well, no, I don't know what inspired the notice of injury. That's we're speculating here. I think they're supposed to promptly complete the notice of injury. Now, the claimant has to sign it. That's required by statute. And sometimes there's a problem getting the claimant in to sign it or whatever. But they got the notice of injury finally to the carrier, and I agree that they were a little bit late on September the 10th. And that's when Gallagher Bassett first became aware of this case on September the 10th when they received the notice of injury. They opened a claim, they assigned it to a medical-only adjuster, and then on September the 11th, they set the appointment with Dr. Green, the orthopedic surgeon, and that day at 2:01 in the afternoon, the employer either emails or faxes them the petition for benefits, and that's when they received it. The next day on September the 12th, they emailed the claimant attorney, Mr. McKnight, to advise him an appointment has been set for your client to see Dr. Green on September the 15th. And so I think within that context, the claimant did not prevail.
So your position is you prevailed on the petition?
Well, I don't think anybody prevailed. This is a self-executing Workers' Compensation Act, and it worked. The carrier did his job. This is actually very rapid to have these things happen this quickly. I was very impressed by the carrier's action in this particular case. I don't think anybody prevailed. I think that the self-executing provisions of the Workers' Compensation Act worked, and the claimant timely got medical treatment. I've gone over my time.
Thank you, Mr. Hess.
Thank you.
Mr. McKnight?
Your Honor, as it applies to whether the claimant prevailed, I think the JCC's order is instructive. It helps. On paragraph 5, she notes that that section of the statute directs the JCC to only consider benefits secured by the attorney. And so I believe in that paragraph she's addressing benefits secured by the attorney. She goes on to state that because the benefit was timely provided, no fee is due. And so I understand the judge to be ordering it that the claimant did prevail, but not more than 30 days after. And that the sole reason is that it was provided within 30 days, not that she didn't obtain it.
So what's that language again? This is a finding that the petition resulted in the benefits.
She says, as employer carrier timely provided the benefit, no fee may be said to be due to claimant's counsel. She didn't say because the claimant didn't cause it to happen, but just because it was provided quickly. And
Well,
while,
that means she didn't reach the other issue.
I think the way she's approaching it, the first sentence before that says, the JCC claims to consider only benefits secured by the attorney. And so she's only considering those that the petition caused to happen.
What does the preceding sentence say?
Section 440.34, Parents 3, Florida Statute 2014, directs the judge of compensation claims to consider only those benefits secured by the attorney when awarding a claimant's attorney fee. There are a lot of time periods in the statute, but none of those time periods are related to costs. They don't say that costs shall be awarded only if a time period. They don't reference costs. The part that references costs is mandatory. And it denies judges the discretion to deny costs on the basis of whether a party acted reasonably.
So you think costs have to be awarded in every case to one party or another?
Where a party prevails.
So you would agree, perhaps with opposing counsel, that there will be cases in which neither party prevails?
This court has referenced that possibility passingly. I haven't found that to have occurred previously, so it could be possible that neither party prevails. But here, entitlement to the benefit was established, and so I believe that should be sufficient to prevail.
Well, no, you're not telling us that even informally there was some request for this medical treatment that was turned down.
It may not have been specifically turned down, but the orthopedic care wasn't provided. And to not provide the benefit is...
Or did you plead what steps had been taken before the petition was filed in an effort to obtain the benefits?
There is on the petition a certification that good faith steps had been taken to resolve the dispute.
But they're not specified.
No.
But we should take, so is that something that we need to have fact-finding about whether that actually occurred?
It was pled and it wasn't disputed, so I think it would have been waived.
Okay, he said they did file in 14 days. What did they say when they responded?
They responded after she went to the doctor, and let me see. They didn't deny entitlement. I could read their response, but I'm not sure.
It says that we've already furnished benefits.
Yes. It says that the orthopedist is authorized and claimant attended the initial appointment. If there are no further questions, thank you.
Thank you. Being that we have no other cases on the docket